a difference. Testing. Would that make a difference? There was one more thing that wasn't clicked. I forgot.
I'll send a message to everyone. So.
Yeah.
Okay, Suzanne heard us that time. Great.
Okay, there was a button to join with audio, I think.
Oh,
Perhaps
okay.
that was just forgotten.
Got it. Okay. Excellent.
Do you want to be muted now or keep it?
No, I think we're good. I think we're about to start. Whenever the chair is ready.
Good morning. I'm Jeff Ashby. And on behalf of my fellow commissioners, I welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I'm asking each of you who may have an electronic device like a cell phone or
You should
pager.
say it. You love saying pager.
I do, to ensure that they are silenced now. We have an agenda and we have additional agendas, including the consent agenda available in the back of the room. The consent agenda is a listing of cases in which no written arguments were made to the commission in the allotted period. The commission has voted on those cases and they will not be considered further today. And so I have called this meeting to order, and first order of business is to adopt the agenda and consent agenda. I'll entertain a motion.
Before you do so, Commissioner, I would just let you know that there has been one change to the agenda as of yesterday afternoon. In one case, E220044, Karen versus Lewiston Public Schools, the council have asked for medical reasons to postpone that till April. There's no objection on either side, so if we could table that case. That would, so then when you're, whoever's making the motion, it would be a motion to adopt the agendas as amended.
As amended. And I will entertain that motion.
Second. We needed a motion. Was there a motion?
Well,
You said you would entertain a motion.
I entertain it. I'll take a motion. Yeah.
You juggle or something? I mean,
Okay.
I prefer not to make motions, but I will, as people insist.
We need a motion,
Motion to adopt the amended consent agenda.
seconded by Julie, I heard. Yeah. So commissioners, as you may recall, because we have, oh, actually, we don't have any commissioners participating remotely, but we have people. All right,
do it
so
just in case.
even though none of the commissioners are participating remotely, because participants are, I will ask, I need each of you to demonstrate your vote on each and every matter, both visually and verbally. So I will call you in order of seniority, switching Tom and Mark all the time to confuse them because they were appointed at the same time. So this is a motion to adopt the amended agendas. If you say yes, you're in favor. Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner O'Brien? Yes. Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Thank you.
Next are the commission meeting minutes from February 13, 2023 meeting. I'll entertain a motion to adopt those.
Actually,
Move adoption with the February minutes. Second.
so it's been moved and seconded to adopt the February 2023 minutes. If you vote yes, you're in agreement. Commissioner Ashby?
Yes.
Mr. David?
Yes.
Commissioner O'Brien? Yes. Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
Thank you.
And next, Amy, director's report.
Yes, director's report. You have first for administration of personnel memo from me noting that investigator Courtney Byrne tendered her resignation, which was disappointing. She was great, but she had other things that had nothing to do with the job itself. She did not pay, which is a sort of a recurring theme that we face all the time. They can make much more in the private sector than they can here. So she left as of 2 weeks ago. We posted the job as soon as she told us. We got 24 applications. We're interviewing, I believe, 8 people this week. Next, for compliance, we have status of reasonable grounds cases. We had no successful conciliations since the last meeting, 6 unsuccessful conciliations, and 7 conciliations are in progress. So we don't have any conciliation agreements for you to approve. Thank you, Chelsea. Yes, we should unpause the recording. Thank you. Thank you, Chelsea, who has just noticed that our recording did not start. I don't think we need to do anything. No. Okay. That's okay
Got it. Okay.
So for investigation, you all have a case activity summary that shows, in February, we received 64 new complaints. I administratively dismissed 7 cases, and there were 10 predetermination settlements. In the past, I was able to tell you how much complainants have received in predetermination settlements, but I can no longer tell you that because the EOC system that we require to get that information at the moment is not providing that. So complainants got some benefits in those 10 predetermination settlements. Litigation, I would ask that we take after executive session, which would bring us to new business. And the only new business I wanted to tell you about was that the legislature is in full swing. And because it's a long session, there's a lot of legislative activity and the biennial budget. I think I mentioned at our last meeting that the governor had put more resources for our agency than we have. I have seen in my 12th year, including 2 new positions, which is amazing. Our biennial budget stuff was heard and went through work session. All of the governor's proposals were approved by the Judiciary Committee. The Appropriations Committee is working on them now. On Friday afternoon, they approved all of the sort of routine things, including commissioners' mileage reimbursement, which has never been in our budget before. They did not address, and this is not good for us, this is for pretty much all agencies. The way the Appropriations Committee does this these days is they take all of the unobjectionable things, the things that are the same for all the committees, like Human Resources Service Center, insurance. They take all that stuff, they just knock it out of the way, and then they leave for themselves things like new positions, things that are new money, or big requests. So all of the routine things have been approved, and our 2 new positions, along with 1 reorganization, remain for them to deal with. I have no reason to believe that they won't end up in the budget. I am cautiously optimistic.
I just want to say that budget memorandum to the legislature is an excellent educational tool for commission.
Oh, good.
It really is. I mean, I look through it. What's the nomenclature to use the word initiative?
That's just what, so the legislature has its own verbiage, and there are a lot of very rigid rules about legislative ideas and new money and things like baseline budget is a term of art, initiative is a term of art. Everything at the legislature has its own term of art. An initiative just means a request for the Appropriations Committee to approve something.
Right.
And some of them aren't new money at all. Some of them are just moving monies from one account to another, changing how a position is funded from state to federal. It's just anything that we need appropriations to approve. So that's that. As I mentioned, there are a lot of legislative proposals that either relate directly to the Maine Human Rights Act or the commission, or that touch on work that we do. And so we already have testified on, I think, 1 or 2 bills, and I think I gave you copies of those. So you can see what we're doing in the commission's name. I think we have 3 public hearings tomorrow. We have another one on Thursday. We have ones on the 21st and the 23rd, and there'll be more after that. So we're busy and we'll give you guys copies of everything that we do. But so far, so good. That's the short version. That's all I have for new business.
So
Julie?
You will send us, I don't think I have that.
It should have been in the new business folder.
The way this was this time was very confusing.
Was it?
Yeah, we'll talk later about that. So,
LD 707.
Yeah, LD 707.
no, okay, so, but can you send us, do you send it monthly? I mean, what you've done in, or in advance, or?
We don't write things far enough in advance to send them.
Yeah.
So it's usually sending them afterwards, like for commission meetings.
Amy, even if you did know, what's happening in conciliations, I don't want to know, but I want to ask you generally,
Yeah,
broadly. This number of unsuccessful conciliations seems like a high number, and the proportion of successful conciliations seems very, very low.
Yep.
To infinity, I guess. The date failed is the same date for all of the
Yes.
conciliation. Can you help us understand this?
yes. So in terms of the unusually solid number of unsuccessful and successful, I would venture to say there's nothing other than randomness related to that, because it's different mediators mediating every case. And sometimes it's a respondent or a complainant didn't want to participate. Actually, it's almost never the complainant that refused to participate, but some respondents refused to participate. So I can't tell you without Jane here on these particular cases why each one failed, but each one is a completely unique facts circumstance. In terms of the dates, the date used is the 90 days after. So the reasonable grounds finding, we have 90 days by statute to try conciliation. And on the 90th day, if it has not settled, we will declare it failed. So that's the 90th day, because we like to give it every possible opportunity for something to happen.
Oh, so that's why it's the same day.
Exactly. Right.
And the conciliation is with an outside mediator.
We use our same roster of mediators who do our third-party mediation program. They're all excellent. They know the Human Rights Act. They're great mediators. They're known to the communities that litigate with us. And we use the same mediators for both, for conciliation as well. And actually, that's one of the things that we got money for in the budget. We've never asked before for the state to actually provide us money to pay the mediators for that. So if it's an EEOC case, we can use EEOC money. If it's a HUD case, we can use HUD money. But there's a small number of cases that are neither EEOC or HUD. And so we actually, for the first time, asked for and got a small amount of money, $2,400, to pay mediators to conciliate like public accommodation or education cases or employment cases that aren't dual filed.
All right, well, thank you, Amy. It's 8:42. We'll take a break and return at 8:45. 3 minutes. And we'll
Enjoy your 3 minutes.
hear the balance of our cases on the agenda.
Yes.
I do have the.
You do have the thing? Okay, and I'm sorry, I know the setup isn't ideal. I'm hoping, go ahead, Julie.
Is it is everyone the same or is it?
Yeah,
just my-
everyone's
Okay,
the same.
okay,
Everyone is accessing the exact same link.
the way, okay.
Yes.
You have my iPad?
I don't have it. OIP is coming this afternoon.
No, but will I have one?
Yes, you will.
Thank you.
And I'm sorry it's taken so
No, that's
long.
fine, that's fine.
It's actually not fine, but
Yeah, okay, okay.
it's not at all fine, but
Okay.
thank you for saying that.
My office is next to Amy's, and I have lost track of how many hours I've heard her on the phone with these people trying to get access to them, so.
I didn't get that email, by the way.
I know, I got it.
Okay.
It's a whole, I'm not sure yet.
Let me know if you need me.
I will, thanks. I try not to bug you unless I need to. It's a fun game we play.
I still owe you that thing.
Yep.
I mean, I'll do it.
It's okay, it's,
Like I'll poll my colleagues during a break just to
I'll
make
make
that.
sure to be so,
I won't meet with one of them at a time so that it
That's
isn't a
right.
meeting.
that's right.
We're referring to
Ooh,
Amy's evaluation,
my
which
annual
is
performance review.
just, it is annual. It's my first opportunity to evaluate Amy. And I think I'll poll each of you, right, just to see if you want me to add anything. I'm gonna let you show my hand.
I'm done listening, you gotta be careful, Betty.
Yeah, if you aren't ready, then that's fine. I'm checking. Check my patio.
I believe I'm first. Yes, that's right.
Gotcha,
Yeah.
yes.
Yep.
That's a good point. You could say, nothing bad to say so far, but the jury is out. So that, you could say, not enough finely marbled meats showing up.
She always harasses me. They're discussing polling each other. I'm not going to take you to the polling. I'll just write it.
Somebody,
To sign
I'll
in.
just sign it, just write it,
That's also problematic.
showing my hand. that
Also
it's
problematic.
not gonna be negative.
With Commissioner Douglas and we'll get it done. That's not a good approach. I don't like.
Right.
No, thank you.
Senator?
Why are we in executive session?
I've been
I'm
invited.
sorry, decline. Sorry, I was, preparing for later.
All right, you ready?
We are.
It is now 8:45. The remaining cases on the agenda today are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. The commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time. No new information or any written materials will be accepted today. Cases will be called in order on the accepted agenda. As I call each case, the party who has submitted a written argument will be called to the podium to provide the most relevant arguments to the case. The time is limited to 10 minutes. Time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded. Procedural rules of the commission specify that your arguments may address only 1, relevant factual errors, 2, relevant omissions from the report of facts submitted during the investigation, or 3, relevant issues and questions concerning interpretation of the law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposite party. Please be advised that commissioners may ask questions. I will ask that you introduce yourself as you come to the podium, or if you're electronic, as you commence your work on the screen. The first case on the agenda today, I hope, if I have it right, is MHRC number PA 21-0055. That's Earl Byler versus the Maine Department of Corrections et al. That's a no reasonable grounds case, so I expect that we would hear from the complainant or his counsel.
I believe Mr. Byler is here remotely. If you want to turn your camera on, you can do that and unmute yourself.
Director, I believe he's appearing by phone only.
Oh, by phone only. Okay, thank you. All right, so Mr. Byler, and I don't actually know if it's Beeler or Byler. Okay, there you go. So you have 10 minutes, and I would just remind folks not to use the names of any third parties, people who are witnesses who are not named respondents to the case. We've given them pseudonyms in the report. With that said, go ahead, Mr. Byler. Can you hear me?
It's like,
Okay, so there you go. You were unmuting and I muted you accidentally. Can you unmute one more time?
Yeah,
All right.
I'm not that person. This is Mr. Tomaselli. So
Oh, okay. I apologize, Mr. Tomaselli. That's the wrong case. We are waiting for Mr. Beeler, and I believe that counsel for the respondent is currently messaging with the prison folks to find out where Mr. Beeler is. Why don't we give it a second? I do see the folks from the second case are here, so if we can't get Mr. Byler, you want us to do that? You want us to go ahead with the second case?
Yes, please.
Okay. Unless folks object, Mr. Chair, I would recommend that we go ahead with the second case.
all right, then we will proceed to MHRC number I gotta get this right, and make sure I'm right with the agenda. PA 21-0339 ABC, that's Bradley Lehman versus
You were so close.
I was.
Tomaselli.
Okay, sorry about that, Mr. Lehman. You're next, maybe after this. All right, let's proceed to PA 21-0044. Zachary Tomaselli versus Wellspring Inc. My apologies. That is a no reasonable grounds case, and I expect that we would hear from the complainant or his counsel.
Mr. Tomaselli, you have 10 minutes.
thank you. Well, first, I just wanted to point out that Wellspring is a 6-month program, and it involves treatment of certain antisocial behaviors that lead to substance abuse. And I really think that it's important here that you guys understand that it's a 6-month program, because the respondent in this case, I believe, realized that there was a major discriminatory issue with their decision to discharge me in July of 2020. And that is why throughout the entire proceeding, they have shifted the focus on issues that occurred in March and early April of 2020, and really didn't answer the discrimination that occurred in July of 2020. As I mentioned, I had some antisocial behaviors that led to my substance abuse, and early in treatment, some issues occurred where I violated the rules of the program, which was placed on a behavioral contract, which was highlighted by the respondent. And a behavioral contract really could lead to discharge at any moment. And as I went on this behavioral contract, I worked very hard to get off of the behavioral contract and went months without any rule violations. I held leadership positions within the program, such as head of the house. I was actually very, very proud of all the things I did. I earned credibility with my peers and my counselor. I was asked to mentor another peer, which was brought up through this case. And I was assigned to mentor him. And that's what led to a lot of these homophobic comments that came my way. And because this peer I was asked to mentor had some feminine qualities about him. And eventually that's what led to the issues in July of 2020. So really, it's at this point that I feel that I've really separated myself from all of the behaviors the respondent lists as the reasons why I was discharged. Sure, other clients have been discharged for these behaviors, but they never really overcame them like I did. They just continued to violate the rules while I was on the behavioral contract. So it's misleading when the complainant states that other clients were discharged for the same behaviors as me. So that's why I feel like Exhibit A that I gave you, the commission, is so important. My counselor, who happened to be on vacation when I was discharged, expressed that I was ready to graduate the program just mere days from when I was discharged. Graduation is Wellspring's highest honor. They can give you other things such as completion, regular just discharge without discipline. But again, they were ready to give me graduation. This again shows that only the accusation presented at the time of my discharge was relied on for my discharge. And really, as I'm about to address, that's really where the primary discrimination occurred. And at that point, I really understand that rehabs can't be asked to do serious investigations and must err on the side of caution, but they also have a due diligence to protect someone from being discharged and subsequently going to jail, really simply due to homophobia. And in my case, 2 newer clients claimed that an individual I was assigned to mentor was in my room, which isn't allowed under Wellspring's rules. They also alleged that I was buying gifts for sexual favors for this person. But really, when I break this down, first, staff never went to me or my mentee until after I was discharged. Also, the 2 clients who brought their concerns and allegations to staff were homophobic, for which I've shown proof of that in my exhibits and for which staff ignored. And also, those 2 homophobic clients never claimed to witness anything sexual or any of the gift giving. Also, the staff do rounds at Wellsprings, like I mentioned in the complaint, like the officers would do at jail, and they never witnessed anything sexual or any rule violations at the time of my discharge. The rules that Wellsprings provided at this were updated after my discharge. So the rules provided to the that you guys have are updated after I had been kicked out. So the rule, but even so, the rules only state that it is a dischargeable offense if someone goes in another room, not if someone has a client in their room. And so I would argue, surely it really wasn't up to me to sit there and guard my own room. And the other client wasn't discharged for coming in my room. The rules also say that Wellspring doesn't get involved in issues of buying gifts for others when it really says simply that it is discouraged, but it's not their responsibility. in the copy that is provided by the respondent. Furthermore, I really begged and simply asked, I asked the respondent to ask my mentee who was buying him things. And it, as I mentioned throughout this case, that it was a guy whose mother had won $15 million off a Connecticut lotto ticket. And I could have proven that, but the respondent gave me no chance to defend myself. The first time I heard these accusations, I was discharged in handcuffs. The mentee I had, as you can see in my grandmother's statement, calls my grandmother, and at one point he's hiding in the bathroom, stating he couldn't stick up for me and have contact with me after he initially told her I did nothing wrong. The mentee would weeks later change his story and state that I raped him, which I had to be vindicated from the Bangor PD. But I don't really even blame him at all, because he was desperate for clients to not think he was gay and distance himself from me in being gay. And at that point, in my opinion, homophobia won the day. And what really keeps me going is that this can't happen in places like this. A quote really that really upset me and keeps me going to this day is a quote by the director of the men's house at that time, Travis Lenfest, when he said on the way out the door, and I put this in the complaint, when he said, when I was told that by having my mentee in my room, that it was the same as a heterosexual male having a woman from the woman's house in his room. And that's to say that because I'm gay, that by having another man in my room, that they're assuming I was having sex with them. And that's really their grounds for discharge. And that's really all they had to discharge me at the end. The other stuff was at the beginning of my time there and really is completely separate. And that's what the investigator relied on. But I don't think the investigator understood how far apart those behaviors were from the end. Thank you for your time.
Thank you. Any commissioner questions for Mr. Tomaselli at this time?
Maybe just one.
Commissioner Douglas?
Mr. Tomaselli, good morning, sir.
Good morning.
Yeah, I just want to make sure I understand your argument. I've read your submission here and I've read the report, and one of the things that stands out to me is that, footnote 3 of this report says that, in the last 2 years, 30 people will discharge for disciplinary violations, most of them being heterosexual. And so I guess what I'm hoping you could do for me, maybe in the next minute or so, is just sort of distill sort of the best evidence that you feel you have that your discharge was based on homophobia or the fact that you're a gay man. What's the best evidence for that in your review?
I would say the fact that I was a week away from graduation, that I had a graduation letter from my counselor, and how there was the lack of evidence that I did anything wrong, that I was just, the minute my counselor went on vacation, that there was no evidence of me doing anything wrong. And suddenly someone who's earned credibility and earned their way through the program with a week left in a 6-month program just gets kicked out and goes to jail without any discussion or anything, because he's mentoring someone else perceived as being homosexual.
Right. So you feel like assumptions were made based on the fact that you're a gay man. Is that fair?
100%. Yes.
All right. Thank you, sir.
Thank you.
Commissioner David?
Mr. Tomaselli, good morning. The report indicates that you signed a behavioral contract. Is that correct?
Yes, that's correct.
Is it your position that there were no violations of that contract?
Yeah, that's correct. The behavioral contract happened in April, and I came off of that contract about after a month. I was put on it for about a month due to the behaviors. Like I had some issues that I think there was issues that were put in there. I smoked in the house. I shouldn't have done that. I was stressed out. I had COVID, or I was sick, and I was scared that people were going to think I had COVID. So I lied about having a COVID test, which caused even more issues. And so they put me on a behavioral contract for a month, and I had to do good for a month without having any more issues, which meant I wasn't allowed to have my cell phone. I wasn't allowed to have any more issues. And I abided by that contract. I had no more issues, which allowed me to come off of that contract in about a month and regain all of my privileges.
Okay, so you're saying that the contract had expired.
Yes.
All right. The report also says that you didn't report the hostile environment. Correct?
I'm sorry.
That's the report says you didn't report the hostile environment. You're saying you're alleging that there's a hostile environment with homophobic discrimination.
Yeah, I'll concede that at the beginning there was stuff I put in there, like there were condoms on bananas and stuff that I just kind of let go. As far as the hostile environment towards the end, where the two guys who were homophobic and the stuff that was going on at the end, I definitely told that to my personal counselor, who he's part of Wellsprings, but he's off-site and he's a mental health counselor. And I've provided copies of that with my report, but it's not specific. It says that I brought up issues. The very last week I was there, I said I brought up an issue, but I wasn't sure what to do about it. And at the end, I balanced pluses and minuses with them. And really, I had a week left, and the pluses, what we balanced out was to just kind of suck it up and get through it, because I was about to go home. And that was with Richard Bissell, the personal counselor I had. Also in there, I told him that I didn't like that I had this mentor, or this mentee that I had. And there were some issues going on with that. And that I was worried about the perception there, and that was provided in there. Those are the times that I really said, that's the only person I really said anything to. So I really feel like most of the discrimination really came at the discharge specifically.
Thank you.
Thank you.
Any other commissioner questions for Mr. Tomaselli? Mr. Tomaselli, you'll have about 2.5 minutes left when we come back to you.
Okay.
Now we're going to turn to counsel for the respondent. I believe that's Mr. Raines.
Yes, can you hear me okay?
Yes.
Thank you. I'm going to be fairly brief, but I would like to reserve the remainder of my time for rebuttal. Complainant disclosed his sexual orientation early on in his stay with Wellspring. He was in the men's resident program. He did not report any issues of harassment during his time at Wellspring. As he noted, he did enter into a behavior contract for multiple rules violations at the end of March, on March 31st. The rule violations included dishonesty, not adhering to COVID-19 restrictions, smoking within the treatment building, going into other clients' rooms, violation of his bail conditions, using a cell phone and the internet without tracking software, and potentially giving gifts to other clients. So that's his behavior contract that was entered into at the end of March. He was discharged from the program on July 7th due to repeated rule violations, including purchasing gifts for a client on multiple occasions. All of these rules, I'd like to just stop there for a minute. All of these rules, not only were they in writing, but they were explained to clients of Wellspring in person also. The other reasons for discharge were having a client in his room after curfew, making inappropriate comments to other clients, dishonesty, using internet without probation approval, manipulation of others, and arguing with staff. As noted in the information provided to the investigator, Wellspring has discharged both heterosexual and homosexual clients for the same reasons. That was not unusual in any way. And we request that the commission adopt the investigator's findings of no reasonable grounds.
Thank you. Questions for respondents counsel at this time?
Maybe just one fairly obvious question.
Mhm.
Good morning. The complainant states that one of the primary components of the discrimination claims is that he was discharged with maybe a week to go
Mhm.
In his program. Do you care to respond to that in any way?
I believe that timing is accurate, but the rules violations dictated that he be discharged, and that's what the program did. I don't know any details beyond that. The timing appears to be correct, though.
Right. I just want to establish there's no provision in these rules in terms of providing people with leeway based on how close
No.
they are to completing the program or anything like that.
That's
Doesn't
correct.
factor it at all.
That's right.
Thank you.
Mr. David?
Good morning. Are you indicating that there were rule violations after the contract was signed?
Yes, that's
So
correct.
there's a factual difference here. He just told us that after the contract was signed, there were no further rule violations.
Well, for one, excuse me, are you finished with the question? I'm sorry.
No, that was the question. That was the
Yeah.
question.
Yeah, so there were additional rule violations on the day of his the time of his discharge. At that time, he had a client in his room after curfew. That's one example of the multiple rule violations that happened after the behavioral contract in March. So that was immediately preceding his discharge.
And another question is there any internal mechanism for him to have a hearing, a discussion, a meeting about the allegations about these rule violations?
Yeah, I'm not aware of any post discharge hearing rights available to residents.
Pre-discharge.
Or pre-discharge for that matter.
Yeah.
I'm not aware of either.
All right, thank you.
Any other commissioner questions for Mr. Raines? Seeing none, you'll have about 8 minutes left when we come back to you. So now, Mr. Thomasali, we turn back to you. You have 2.5 minutes.
Thank you. I just want to say real quick that I would ask the commission to look at the rules. There is absolutely no rule provided in there that says anything about giving he says that there's rules provided that say giving clients anything. I want to say that I never did give a client anything, but as far as monetary value or anything like that. But even so, he says that there was copies of that's in the rules and it's not. Also, he says that it's in the rules that that clients can't go in another person's room. So that's correct. I didn't go in anybody's room. I had somebody who was my mentee who was in my room, and I could not, like, this guy was very, I don't really know how to put it, but he was very attached kind of, and it's not my job to defend my room. Like I said, if anybody violated the rule, it would have been my mentee. Also, I'd like to say that in the earlier behavioral contract, Attorney Raines mentioned that I violated rules such as being in other people's rooms and giving gifts, and that is not factual. Those two rules were never violated back in the behavioral contract. Those rules were only brought up once, and at the end, whenever, and that's important because for those rules were brought up for the very, very first time, and those were the rules I was discharged for. The rules on the behavioral contract were violated once, were never violated again. I came off the behavioral contract. I showed improvement from those rules, never violated those rules again, came off the behavioral contract, had taken myself far away from those types of rule violations, and then suddenly a new type of behavior was accused of me at the very end that had nothing to do with what was on the behavioral contract. And there was no evidence of those rules, nor are those rules even in the rule book. Thank you.
It's great timing, right on time. Any questions from commissioners for Mr. Tomaselli? Seeing none, thank you. Now we'll turn back to Mr. Rains. You have 8 minutes.
The complainant acknowledged and admitted to having a client in his room after curfew. As he noted, that was a separate occurrence that was outside of the time period of the behavioral contract, and that immediately preceded his discharge from the program. His sexual orientation was known from the outset of his participation in the program. That was not the basis on which Wellspring took any action against the complainant.
Thank you. Any commissioner questions for Attorney Rains? Seeing,
Just,
Commissioner
I'm
Douglas,
sorry,
yeah.
just one question. So the complainant just stated that basically some of these rules were sort of made up or not in existence or otherwise not violated. I just wanted to get your brief response to that.
The rules were not made up. The rules were in place. They were pretty well known to everybody. They were both in writing and they were explained in person to residents. You'll note that there are a fair amount of rules, and those rules are important to the program. To say that they were made up is not accurate.
Thank you.
Any additional commissioner questions? Seeing none, thank you, Mr. Rains. So then we would turn to the investigator, Mr. Beauchene.
Good morning, commissioners. Thank you for the opportunity to present this case on behalf of departing investigator Courtney Burns. Unlike defending one of my own reports, my role in presenting another investigator's report is somewhat different. For me, I largely read the entirety of the record and do my best to determine which facts the investigator likely relied upon in reaching her recommendations. Here, complainant alleged the existence of a hostile environment in a place of public accommodation based upon his sexual orientation, as he had mentioned earlier, specifically what he considered to be homophobic slurs, acts, and comments made by other residents and staff. However, in this case, even if that conduct occurred to establish respondent's liability, complainant also had to show that the public accommodation knew or should have known of the offensive conduct. Here, Investigator Burns made a specific finding that the record reflected no complaint about harassment by the complainant, and there was nothing in the record that reflected that respondent staff witnessed or should have known about any of these acts. In fact, the only reference to harassment in the record is that when complainant was specifically asked about whether he was being harassed during a session, he specifically denied that any harassment was occurring and that he could take care of himself. With respect to the second claim about the less favorable terms and conditions, the records that were referred to earlier by the parties do not apparently reflect any apparent bias towards people who self-identify as gay versus any other sexual orientation. As respondent noted, complainant also does not dispute that he self-disclosed his orientation at the very outset of his residency, and he's offered no plausible theory why this never became an issue for respondent until just prior to his discharge. If respondent was motivated to discharge him on that basis, it had multiple opportunities to do so, but decided not to. Lastly, with respect to assessing any other, well, in this case, in assessing the likelihood of complainant prevailing at trial, I think it's reasonable for the investigator to also to take into account his credibility or lack thereof in assessing his likelihood of prevailing at trial. Unfortunately, in this case, complainant has made a number of public statements indicating not only that he takes pride in lying, but that he certainly had the willingness to do so once so. any facts that may have been disputed in this case would be difficult for him to establish at trial, given the credibility concerns. I'm ready to answer any other questions that the commissioners might have.
Thanks, Bob. Commissioner questions for the investigator? Seeing none. Thanks, Bob. So commissioners, you have heard from the parties and from the investigator, or at least you've had the investigative report presented to you. At this time, we'd be looking for a motion or motions. There are 2 proposed findings. Sorry, Commissioner David, go ahead.
Are you doing? No, yes, I'll take them together and move that there's no reasonable grounds that we find that there's no reasonable grounds to believe that respondent discriminated in creating a hostile environment, and the second one, or in terms of condition of service, and the complaint should be dismissed.
There's a second. Commissioner O'Brien. So it's been moved and seconded to find no reasonable grounds on both claims. Is there any discussion?
Well, I'm making the motion because I mean, I think that the petitioner is asking us to second guess the implementation of their own rules. And it seems as though they used those rules. They gave them a number of breaks. But I don't find any discriminatory animus in the way they've used the rules and the violations of them. So I'm just not convinced that there's any discrimination.
Any additional discussion among commissioners? Seeing none. So the motion is to find no reasonable grounds on both claims. If you vote yes, you're in agreement. Commissioner Athey.
Yes.
Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Douglas.
Yes.
Commissioner Walker.
Yes.
So the findings are both no reasonable grounds, and the commission will send both parties and their counsel, if they have them, a letter confirming that, and we thank you for your participation today.
Did we locate Mr. Byler?
I believe he's on the phone there.
And is it Byler or Beeler?
Hopefully, if you can unmute, Mr. Byler. Yes. Are we pronouncing your name? Is it Byler or Beeler?
It's Mr. Beeler, ma'am.
Okay, Mr. Beeler.
The next case is Earl Beeler versus the Maine Department of Corrections et al. That's MHRC number PA 21-0055. This is a no reasonable grounds case. As a result, we'll hear from Mr. Beeler or his counsel.
Mr. Beeler, you have 10 minutes. I'll just remind you not to use the names of any third parties like witnesses. The only names you can use are people who are named as parties to the case. And with that, you have 10 minutes.
Okay, thank you, ma'am. Can you hear me all right?
Yes.
Okay. The main argument within my complaint of discrimination against MDOC is associated with the fact the department, one, acknowledges the diagnosed disability of OUD, two, excluded me from participation or denied me the benefits of the public entity services program or activities, and was discriminated against due to the length of my sentence, and excluded me from an entire category of medical treatment. The MDOC deliberately ignored the reality of the situation at hand due to a history of substance abuse within the prison that shows the medical need at which issues is significantly serious, and was determined by Dr. Prop and medical team, the assistant director of WellPath, who was responsible for recommending residents with the utmost need for early induction to MAT program. It was completely obvious to him that the layout person would recognize the need for the medical assistance. My referral for the early MAT came in July of 2020, approximately 5 months before the early induction program stopped. I suffer from OUD. The state of mind associated with my disability involves reckless behavior, criminal recklessness. Prison officials knew of my behavior and were aware of the facts from which an interference could be drawn that a substantial risk of serious harm existed. Yet, nothing was done to help prevent my OUD, but the MDOC intentionally refused to provide me with the proper help needed based on a non-medical reason, not meeting the time frame for eligibility. 3, the exclusion, denial of benefits, or my stated reason, discrimination, was, and by reason of my discrimination, was by reason of my disability because I maintained a firm approach under which I requested the exceptions be made to help me. No reasonable accommodations were provided. It has been recorded that talk therapy was implemented but doing so is obviously not the medication. The MDOC deliberately prevented me from an entire category of medical treatment that the department policies have made available to me. Denial of rehabilitation services offered by the public entirety was done, and by doing so shows that I was denied by reason of this disability. Pursuit Title 42 U.S.C.A. subsection 12102-1, 12131-1 and 12132. My disagreement submitted on Friday, February 24, holds the burden of proof and does the evidence provided by the respondent submitted to the Maine Human Rights Commissions throughout the investigation. I'd also like to say that, you can't just focus on what was done right, and just ignore and forget what was done wrong here. We have to look at both sides. Also, another thing is, it's been said that my substance abuse it's been said throughout this that I caused harm to myself purposely to get on the program. And my medical history shows my substance abuse all my life and the whole time being here. And I was hospitalized before all this on a couple different occasions. So, thank you.
Thank you, Mr. Beeler. Any commissioner questions for Mr. Beeler at this time? Not seeing any just yet. You'll have 4.5 minutes left when we come back to you.
Okay, thank you.
And now we will turn to respondents, and that's Attorney O'Brien.
Morning, Commissioners. My name is Jill O'Brien. I represent the Maine Department of Corrections and the individual respondents, the Commissioner and Deputy Commissioner of the Department. Wanted to give you a bit of background about this case. The Maine Department of Corrections started a pilot program in July 2019 that would provide access to medication-assisted treatment for substance use disorder to some of its residents. It couldn't roll out the program to all 1,800 residents overnight because there are strict federal prescribing requirements for prescribing medication-assisted treatment. We're talking about Suboxone and Subutex. One medication was available at a time, but the department at one period of time would use Suboxone, at one period of time use Subutex. So the pilot program started specifically to reduce harm from opioid use disorder and specifically focused on release from prison. There were terrible statistics about deaths and harm that was happening upon release. So the pilot program started to provide Subutex to those for whom it was medically appropriate and who were within 90 days of release. Mr. Beeler, unfortunately, will be in prison until 2057, so he did not meet that criteria. In February 2020, they expanded the program to those within 6 months of release, then a year, and then 18 months. And within 2 years, so from July 2019 to August 2021, they had provided it universally to all residents of the department for whom it's medically appropriate. Mr. Beeler was actually placed on medication-assisted treatment in May, so before complete universal access, he was able to access the treatment in May. Mr. Beeler told you that he was delayed in receiving this treatment by reason of length of his sentence. And that's true. He wasn't denied this treatment on the basis of his disability. We have the definition of disabled is complex, and it actually excludes those who are currently using illegal substances. So the department maintains that he's not technically an individual with a disability under the laws. But even assuming that he was, he's not entitled to the treatment of his choice. He told you today that there were no reasonable accommodations provided to him, but he forgets that he was offered individual and group therapy. He participated in both. Dr. Prop met with him frequently in the fall of 2020 until Mr. Beeler decided he didn't want that anymore in January of 2021. And he completed a group substance use disorder program called Stages for Change. So overall, the important thing here is that his decisions weren't made on the basis of any disability. It was part of a very progressive program that is now universally available.
Commissioner questions for Attorney O'Brien? Seeing, Commissioner O'Brien.
Thank you. People confuse us.
Any relationship? No.
Not that I know of.
Okay.
So currently, how many people are on the list? I think you said that it's universal now, allowed. How many are on the list and what makes that decision?
Sure, I think at last count, I want to say there were between I don't want to misspeak, but I think approximately 700 residents were enrolled in medication-assisted treatment. And the recommendation is always made by their doctor, who then, there's a process. You have to have a substance use assessment, and then you have to pass a drug test, because there can be very dangerous interactions if you're, for example, if you're using fentanyl and you take Suboxone, you can depress your system and perish. So that's the current procedure.
Okay, and if they are currently using, if the drug test, I mean, I assume there are intermittent drug tests throughout the program. And if they fail a drug test, then they're out. Is that
so? There are random drug tests in prison always.
Yeah.
And if you fail a drug test, you will meet with your provider. I don't think they immediately stop, because once you start on Suboxone, you're on it for potentially ever, and immediately stopping can have deleterious consequences too. So I think those are all provider determinations. Certainly they wouldn't give it to you that day, but they wouldn't simply stop.
right? Thank you.
Sure. Any other questions?
Let's just assume that the complainant is disabled, right? get into this analysis of whether he's disabled or not, we'll be here all day trying to figure out factual questions. Let's assume he's disabled. Is it a fair inference then from your perspective that there were other people in, in the same facility that he's in were disabled, right? Or delayed access to the program because of logistics, as I understand what you're saying.
Certainly, there were others, the commission has heard other cases, in fact, who were in a similar situation. Someone with a life sentence, for example, was factually not eligible for the program until August 2021. And that is true. But the key is that the decisions were not by reason of disability. Mr. Beeler and others who you hypothesize were not denied access to a program because they were disabled. That's not what was happening here. He wasn't treated differently from other disabled people.
It just had more to do with the sort of logistics of implementing this program and bringing people on board and the requirements at any particular time. Is that fair?
That is, and trying to focus on imminent harm reduction for those exiting prison, which certainly doesn't assist those who have a very long prison sentence. And so it wasn't until, in Mr. Beeler's case, May 28th, 2021, that he was eligible for the program, began the program.
Thank you.
Any other commissioner questions for Attorney O'Brien? Seeing none, you'll have about 7.5 minutes left.
Thank you.
Okay, so Mr. Beeler, now we're coming back to you. I muted you, so if you could unmute yourself again. You have about 2.5 minutes left. I'm sorry, 4.5 minutes left. Apologies, 4.5 minutes.
Okay, thank you. Just a couple things on what Ms. O'Brien had to say about the prevention of harm prevention. There was a team put in place here and throughout the DOC that was for early induction, and that was for people that had longer sentences and that had a stronger severe problem than others, and there was a team of 5 different doctors, and this is the biggest thing of all. I was seen by all them guys and put forward in July of 2020 to receive the early induction, and I was just ignored, and it didn't go in effect that they took it away until December of 2020. And I met weekly, sometimes 2 weeks with the doctor for almost a year. I did that program. I did it, and it's just what I went through at the end of the day was, it shouldn't ever happen. It shouldn't ever happen to anybody. And that's the only reason why I'm here today doing this, because I almost lost my life due to it, and it happened a year or so before that, and it's separately in accounts because of this, and and the harm prevention, that's the main thing. I have no argument with that. That's the whole reason why I'm here doing this, and I guess that's all I have to say. Thank you.
Thank you. Any commissioner questions for Mr. Beeler? Seeing none. Last call, commissioner questions. Commissioner Ashby, you'll be thinking about it.
No, I'm going to wait for
Okay.
the representative from the respondent.
Thank you, Mr. Beeler. Back to respondent. You have 7.5 minutes left.
Remember to take my mask off this time. Mr. Beeler referenced the early induction program. So even in July of 2019, when the pilot started, they recognized that there may be a situation that would need an exception. So a medication assisted treatment review committee was formed and would hear referrals from prescribers for cases that may merit consideration under the early induction program. Over the course of the program, before it was universally available, 8 individuals were inducted early. So it was a very rare case. Because they were balancing the fact that this material is often trafficked. And what Mr. Beeler is referring to in nearly losing his life is that he was hospitalized twice for injecting the saliva of other prison residents to obtain the drugs in that saliva. And prison residents were engaging in that kind of dangerous behavior in addition to self-harm, threatening prescribers with board licensure complaints, all in hopes of getting recommended for early induction or to go to the hospital and have access to more preferred medications. In light of that, the department halted all early inductions in December of 2020 and decided to push for universal access as quickly as possible. So I just wanted to put some of that into context. Mr. Beeler, in our submission to the commission's first round of questions here, we outlined that Mr. Beeler had a number of trafficking offenses. Prison had to manage what is a very substantial risk of trafficking this medication with the opinion of his providers as to what was best for him, whether it would be dangerous for him to be using other substances and taking Suboxone at the same time. And at the end of the day, they offered him individual and group counseling instead.
Thank you. Commissioner's questions, Commissioner Ospey.
Yes, Mr. Byler's rebuttal and then your response, they're helping me sort of zero in what I think the claim of discrimination is. Do you understand, like I do now, I guess, that at least one claim of discrimination is that he had applied for this early induction program and wasn't notified one way or another? He certainly wasn't accepted into it, but wasn't notified one way or another as to whether he would be accepted in it?
That's not the department's. I'm flatly very surprised by that, and that was just raised very recently. So he was, Dr. Propp referred him to the committee in July, as Mr. Beeler said. In August, he had the substance use disorder assessment that one would have to get him ready in case the review committee said yes. In September 2020, the MAT review committee discussed his case and declined to place him in the program. He was meeting with a counselor every week. It would be very surprising that it wouldn't come up or that no one would give him that information if he, and in addition to the department, for example, when they ended early induction, they put out a memo in all of the facilities and on the website, et cetera, to let people know what was happening. And every time the program expanded, there was a similar memo to all the residents because they are the people who need this information most. The department disputes that to the extent he seemed confused by that. He was certainly made aware before beginning the MAT program in May of 2021. He would have had that drug test we spoke about, meetings with his provider about the importance of not continuing to use substances that were not prescribed while on that program. So to put a little more context there, September 2020 discussed by the committee and denied. December early induction stop. May is his entrance to the program.
That's very helpful. That wasn't real clear in the investigator's report that there was. First of all, your earlier statement was that only 8 people were accepted in the early induction program.
That's right.
And there's I assume a process, and I think you just described it, that actually this committee meets, and in this particular case, Mr. Beeler was in fact declined. He got that process.
Correct.
He was in fact declined.
Correct.
A little shaky as to whether or not he was notified about that. You suggest that we should infer that he was because of his continued contact with his counselors and therapists. But beyond that, does the record say whether he was told or not?
So there's probably 3,000 pages of medical records, so I'm disinclined to say that there is not a record of that anywhere.
On the record before the commission to report with what I'm asking.
And there's also an issue that you might notice some of the materials are redacted. So again, it's surprising to me, but I can't say for sure that he was notified on a certain day. Other than to say all early inductions ceased in December. One of his hospitalizations occurred in that November. So he was receiving a lot of health care and a lot of information about his status.
Thank you, that's very helpful.
I'm just curious about the argument about the definition of disability. Is the argument that he's not disabled because he's using in prison, or is it that he's not disabled because addiction is not included in the definition because of its voluntariness or whatever.
So the federal law, for example, substance use disorder can definitely be a disability. There's required that there be a period of sobriety in order to have that qualify. Otherwise, employers, for example, couldn't fire someone for substance use on the job because they'd be disabled. And that would be almost an absurd result. So in this situation, the department is not conceding that he's a qualified individual with a disability because there was no period of sobriety. But even assuming that he qualifies as an individual with a disability under the Maine Human Rights Act and the ADA, there's lacking the discrimination and the on the basis of his disability.
Briefly follow up on Commissioner Aspey's question. Let's just say for a second that perhaps he was not notified in a timely way about his status. In your view, is that unlawful discrimination?
No, and being notified that he wasn't receiving the treatment, he wasn't receiving the treatment. So the end result is the same. Certainly if he had been accepted into the program, he would have had the drug test and he would have met with the provider and discussed there are various levels of Suboxone you can be started at. Those conversations would have happened. So even by omission, not receiving the treatment is some sort of notification that they have not approved his request. Thank you very much.
Any other commissioner questions for Attorney O'Brien? So now we turn to the investigator. Kit Thompson-Crossman was still an investigator at the time that they did this case.
Promise this is almost my last one.
So I just want to clarify one thing regarding your question, Commissioner Ashby. I do not have in the record that the early induction committee denied his request. What I have in the record, and it is true that a lot of what I received was redacted because the dates that Mr. Beeler put on his medical release. So it's possible that that information is in here and it's redacted, so I can't see it. But what I have is that on September 24th, the early induction committee discussed Mr. Beeler and his referral for early induction. And then some stuff is blacked out. And then it says that the clinical team discussed his referral and made a note that the next steps would include speaking with the department about clinical recommendations regarding his referral. It's a small thing, but I don't actually have it in the record that he was denied. He may have been, and I just can't see it. I don't have it. Regardless, I do in the end agree with the department's position that he was not denied treatment on the basis of his disability, and that is what we cover with regard to public entities like prisons. I'm happy to answer any other questions.
Any questions for the former investigator? None.
Yes.
First of all, that was really helpful, and my colleague's question also got to the point of even if he wasn't notified, I mean, I'll be discrimination, but I can't let the opportunity pass without pressing you to suggest that the like public entities such as prisons. Do you want to comment on whether a prison requires is required to follow the Maine Rights Act and public accommodations?
With regard to prisons, they are required to follow a small subset of the thing of the rules that apply and the law that applies to public accommodations. And in this case, that the only thing that we cover is discrimination with regard to disability when somebody is denied services on the basis of their disability. And other than that, not.
Found your argument regarding the MDOC being the contracting agent to be very clever.
Oh, no, there is an entity that contracts with the MDOC that to provide healthcare, and he didn't name that entity. He named some employees of that entity. So yes, there's some there's some stuff that maybe is not very clear in the report based on how the complaint was brought.
Thank you so much.
Any other questions? Okay. So commissioners, you've heard from the parties and from the investigator, and so at this time we will be looking at a motion or motions. There are two proposed findings.
So I'll move to adopt the findings of the investigator but there are no reasonable grounds to believe that the respondents discriminated against complainant on the basis of disability or for engaging in statutorily protected activity. And a complaint should be dismissed.
Both Julie and Ed seconding. So is there any discussion? The motion is no reasonable grounds on both claims. Any discussion among commission? Seeing none. So the motion is no reasonable grounds on both claims. If you're in agreement, you will vote yes. Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner O'Brien? Yes. Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
So the findings on both claims are no reasonable grounds, and the commission will send parties and counsel a letter confirming that, and we thank you for your participation today.
All right, I'm back on track with our agenda. I hope, forgive me for my earlier mistake. I believe that we're next dealing with MHRC number PA 21-0 339 A, B, and C. That's Bradley Lehman versus Tri-County Solid Waste, David Stanley and Walt Wilson. This is a no reasonable grounds case, and we should therefore hear from complainant both cases.
Complainant's counsel is coming in now, and respondent's counsel is online. And you see the investigator. So we just need complainant counsel and be ready to go. He already wants to start. So go to it. Well, we're ready for you.
Morning.
Morning. I'm Susan Farnsworth.
10 minutes, and I'll just remind you that we not to use the names of any third parties who are not named. Giving them pseudonyms in the report.
I have a question, and that is, may I share my time with my client?
Okay.
Okay,
Same rules apply to him though.
yes. So I'm Susan Farnsworth, and I'm here on behalf of Bradley Lehman. And the concern that we have is that the investigator's report really does not take into account the nature of his disability. And I believe the investigator's report simply says, let's take this off because I can't, simply says that he said he had soreness in his hands, but this, my client had presented before I was involved, which is recent, my involvement, had presented a handwritten response that I believe he gave to the commission. So I don't think this is new. And I, by the way, I would apologize for my submission of documents that were new. I just read it backwards in a hurry, and I'm sorry. But he said, and I would just like to briefly read what he wrote to the commission in response to their argument that he didn't show disability. He said, I do have a disability from the VA. It is in my hands. I am rated 30% disabled. Last year, I had trouble walking and climbing, so I was given a handicap placard. I'm 71 years old. It takes time for my hands to heal. I wear gloves. No one can see my disability or my pain. My hands crack, peel, and bleed. They ache all the time. I just try not to let it dictate my life. And I understand, although I wasn't involved, that there was significant discussion in whatever meeting they had by Zoom or by Skype, I think he said, about the ways that when his hands flare up, this condition that he has, he can't do things like take showers, and he can't do manual tasks. The problem for him is that the policy that was suddenly changed at this facility in summer of 2020 meant that his hands were much more susceptible to having this flare up. And I believe the definition of substantial impairment does not require that you have to have this condition at a level that impairs your life, major life activities every day. But if, for example, you had cancer and you had
something that when it did flare up, it would impair, that would meet the definition. That's his situation. He has to work very hard to keep it from flaring up. And this policy change that they suddenly implemented after 25 years of having it the way he's asking that it be, that policy change has meant that he's had much more susceptibility to having these flare-ups. They did not mention, and he mentioned in the same submission I'm talking about, that he has a helper help him load things onto the truck. They didn't see that, so they wouldn't know that. So he has really, as far as I'm concerned, the same kind of argument that somebody who uses a wheelchair would have if they were going to a public building, maybe with some stairs, and they would not allow the person to use a ramp, because if he uses his dump truck, he just has to push a button and the lift raises the dump truck, the load goes off, and so it's not hard for him with his condition. But when they say, no, you can't, you have to take each bag off the back of the truck, that's a lot of handling of trash, and it's often broken at that point, the bags are broken. So it's dangerous for him. It's dangerous the way they've set it up, that he has to stand on top of the truck. But they had somebody sitting there that day, and that person was could have opened the gate and shut the gate after him. So it's no hardship. We've been doing it for 25 years. And I think he will make clear to you that they've changed their story to him 3 times about what the reasons are for this change in policy. And they've ignored his talking about the impact on him. So I believe he has a very clear disability. This is grossly unfair to him. It's not a burden to the facility at all. And he has had this as a continuing complaint. So I really did not understand the timely issue of this. He made some date references, but it's continuing to this day. So I would like to turn over to my client. Could you tell me how much time is left?
5 minutes.
Okay, great, thank you. All yours. You can take your mask.
It's very hard to do. It's hard to explain the pain I go through in my hands trying to do this job when 25 years I did it easily with my dump truck using the body. I'm subject to pain in my hands and feet when I'm up in the body of the dump truck, lifting out over 2,000 bags of trash a year. The Tri-County Board gave Dave Stanley 3 ways for me to use my truck, approved by the state of Maine with my disability. David Stanley.
Sir, I'm sorry. Okay, the name responded. Yes, I apologize. I'm sorry for interrupting you.
No.
Sorry.
Refused all 3 ways. It takes 20 seconds to unload my truck when the gate is open to the trailer with my disability. 25 years I've done this 1,300 times under 3 managers at the facility. By hand with my disability, it takes over 20 minutes for an employee to wait for me to climb up in the back of my dump truck and unload by hand. There used to be several commercial haulers with dump bodies over the years hauling trash. Now, I'm the only one with a disability in the dump truck left. On 2015, Tri-County was written up on 8 violations. One being the gate was left unattended and I was not there that day. But they did not say the gate could not be opened to commercial haulers in their report of 2015. He closed the gate to me 5 years later with my truck. The state has never been back since for an inspection. There is a transfer station. The transfer station was built in 1993 for use of transferring trash from commercial haulers to a dump trailer 40 feet long, 13 foot 8 inches high, below grade. This unloading trash by hand with my disability of age 72 causes severe pain with 2,000 bags a year. I used to be an electrician 30 years ago. I gave this up. My hands were so sore, I cannot use hand tools to do that job. But doing the trash, I could do with a dump truck. I asked and never received a letter from the company as to why we can't dump green bags inside the building, but 150 feet away, outside, I can use my dump body with demo. There was a 4-foot rule from the insurance company. All I wish to today to be singled out with a dump truck with my disability. Use my truck as I did for the past 25 years as a commercial hauler, dumped there 1,300 times with no extra cost to Tri-County. And I'm able to use my dump truck at other transfer stations in Maine. Not to bother you people, but if you like to look at my hand, I'll gladly show. Thank you.
So if you'll wait a second, I want to see if the commissioners have any questions. If there's any questions, okay. And then Commissioner David and others.
I do. I don't know if this is, I'll defer to the two of you to decide who's answering questions. I want to focus on not the gate and the dumping by the gate, but the contraption that you supposedly have built. Is that still something that you have available to you? The use of this device that is like a winch that allows?
Yes, I brought it that one day with a helper with me. I drove into the yard of the Tri-County yard. Mr. Stanley was in a way building. He come over and he stood back and I said, would you please look at this device? I have 13 bags on it today to try. I'm standing on the ground. This is over your gate. You don't have to open your safety gate. It's all safe and it's 4 feet. So these 13 bags are going to go into your empty trailer. The trailer was completely empty that day. Mr. Stanley stood back with me and my helper there and said, you cannot use this today because next time there may be trash in the trailer. And the state law allows a 4-foot overhang over the end of your truck. I was within the law of the 4-foot overhang. Before I got there, I had a black-green net over the 13 bags. It wasn't going to blow into the road and cause any hazard. I also that day brought a 10-foot ladder because I figured Mr. Stanley was going to say no to this. So my helper pulled the ladder on the cement so I wouldn't fall. I climbed up over the sideboard. I'm now 3 feet higher. I brought a hoe from home, a long, wide cement hoe. I held onto the sideboard and pushed the 13 bags off by hand. And Mr. Stanley looked at the bags going down into the empty trailer. As I climbed down the ladder, I said, thank you. This fellow with me today is a witness to what is happening here. Have a good day.
So again, my question is that available to you still? Do you-
Yes, it's still available. I took
With
it.
that, if its use is permitted, or at least not, well, if its use is permitted, would that solve your problem here today? Or do you believe that a reasonable accommodation requires that they also allow you to open that gate?
A reasonable accommodation would be allowing them to open the gate as they did for 25 years.
But if that's not something that we think is a reasonable accommodation, would this device that you have solve your problem?
Yes, this would be another reasonable accommodation.
I have no further questions. Thank you.
Thank you.
Commissioner David?
Well, I'm having a little problem understanding the mechanics. The dump truck is too low to the ground and therefore would hit the gate if the gate's closed. Is that the problem? When the gate is closed, you can't use the dump truck because it doesn't go over the gate.
Correct. The trash won't fall in there because this gate is in front of it.
Right.
And the purpose of closing this gate is to make it safe for everybody. There's nothing safe for me there. It's very dangerous.
And your jury rig that Commissioner Ashby is asking you about.
Apparatus, yes.
The apparatus, I was gonna ask about that.
It has a negative connotation. This might be an engineering model.
Oh, it's a sailing term. You can understand. I thought there was something mechanical in that to push it off.
Yes, I had a boat winch on the side of my body with pulleys hooked up. And this boat winch pulled this rope back that I cranked on the side. And as it come back, this would push the bags off the end that was in the truck.
So the reason that I'm asking these questions is to get to what I think is important. You're saying that he told you that day, looking at it, you can't use that. He didn't cite any insurance inspection or any state inspection or anybody else looking at it to say it would be prohibited.
No, his only answer was next time there may be trash in the trailer, so I couldn't even try it today.
Would that affect the ability? Isn't it high enough to?
Oh yes, it's up over the body of the trailer, up over his gate.
All right, well, I'll have to ask his counsel what he means by if there's trash in the trailer, it would not work. Thank you.
Thank you.
Hold on, one more. Hold on. Commissioner Douglas?
Yes, good morning, sir.
Come on.
I just wanted to better understand. When you offload the bags by hand, right?
Correct.
You don't want to do. How exactly does that affect your hands and your disability? Like what happens? I assume you're wearing gloves.
Yes, I have to wear gloves basically all the time. Because like with COVID, I couldn't use hand sanitizer because of the alcohol, so on and so forth. And I basically wear gloves 98% of the time in the day, other than when I have to use the real bathroom.
So you're saying that when you have to pick up the bags.
Correct.
And put them into the trailer physically.
Correct.
That affects you because of your disability.
Yes.
I just wanted you to explain to us how. I mean, your hands swell, do they crack? Is it something outside of the normal everyday that you experience? Just a little explanation.
Yes. Trying to hold on to these plastic bags, all you got is basically a top. You can imagine this bag fits into a 32-gallon trash can. The people pay $2 for it. So sometimes they jump on that bag to get another 8 things.
Nobody
in
does
there.
that.
These bags, some of them I've weighed them on bathroom scales, they're over 50 pounds. I'm trying to hang on to this little top that they say the bags are gonna be tied going into this trailer. They need to be tied. So I'm trying to hang on to 2 inches of plastic. It's slippery. My hands are sore like they are today. I'm trying to hang on to that. My other hand's down here, trying to hang on to the bag. And on a hot day when it's 110, you pick this stuff up beside the road. It don't take long for that bag to disintegrate. And I'm trying to do this carefully so I don't spill any bags at Tri-County, so they have a mess to clean up. And that's how this aggravates my hands more. Sometimes my helper is with me, loads the truck for me. And sometimes even the people I pick up trash for, they become my friends. I've done this for 30 years. They'll come out and knowing I got a disability will throw the trash onto the truck for me. I don't even get out of it in their yard.
One more question. The disability that affects your hands, if it's in the record, I apologize, because I missed it. Does it have a name?
I didn't hear that.
Yeah, is there a name for the disability that affects your hands? Do they?
It's I think my lawyer had it as Noxzema or some damn thing.
Well, actually, it was my attempt to provide that by asking him to provide his discharge papers that had the name in it. But that's what got redacted because it was considered new, even though, as I read you, he said he had a disability from the VA. So I don't think I can say what it was, but it does have a name.
Yeah, it's here.
I thought it was in there, yes.
Maybe I missed.
In the affidavit, B, it's DYSHIDROIO.
That was the other thing I couldn't pronounce.
Yeah.
Thank you.
Thank you.
Thank you.
Thank you.
So next, Attorney Brogan is here for a respondent.
Thank you, Ms. Newsom, and thank you, commissioners. We appreciate your time today. I think you all understand that this is not personal to Mr. Stanley from Tri-County Solid Waste. I know Mr. Stanley takes it personally, and you can tell by his emotion about this that he takes it personally. The interesting thing is, and you just heard it, Mr. Stanley talks about unloading his dump truck being a huge problem, and there are in the record, as investigator Hurd found photos of him doing that, but doesn't talk about the fact that he has to collect all of this trash and put it over the back of his dump truck into the back of the bed, which is, as you know, certainly above shoulder height. So when he talks about the bags weighing 50 pounds and having been squished down and all the other issues, these are all the issues that he deals with whenever he collects trash and puts them in his dump truck. He then drives them to the transfer station, unloads them from a height into a bin and is on his way. In July of 2020, the transfer station made a decision to do what it should have done, as Mr. Lehman points out 5 years before, and keep the gates closed. I don't know if the commission has dealt with these cases before, but there have been numerous tragedies, and I unfortunately have been professionally involved with several of them throughout transfer stations in Maine, where people have fallen into the trash bins. Several people have been killed. Those problems have to do with how why these safety gates were in place and why they're being used, and why the investigator in this instance found that in fact they were reasonable and necessary. So what happened when Mr. Lehman made his complaint? Well, what happened was the commission took it seriously and decided that they could find a reasonable accommodation. And in this situation, a reasonable accommodation was, could he dump the trash on the floor? Well, if he, in fact, that was number one, dump the trash on the floor and let the employees then put his trash into the bin for him. They found that that would be a safety risk not only for the employees, because this trash, as Mr. Lehman's lawyer pointed out, this trash might be broken or might be broken when it hits the floor, leaving stains, spots, broken glass, a variety of other things, real safety hazards for both the employees or anybody who's loading that into the bin. And for all of the people who are going to be around him, he's not the only person dumping trash there. Next, they talked about having a separate dumping facility for just Mr. Lehman, and clearly that would not work. Then they evaluated as to whether they could close half of the building when Mr. Lehman was there, leaving the other half open, and then put chains and stop barriers to keep people from the side where Mr. Lehman was dumping. Again, that was an unworkable and not a reasonable solution. And finally, they evaluated as to whether or not they could keep they could have him dump after hours and let others pick up his trash for him. Again, not reasonable. So we believe, and we argued, but the investigator did not specifically find that Mr. Lehman does not have a disability. There is significant medical evidence that he does not have a disability. His testimony was that he does not have a disability in the meaning of the Maine Human Rights Act. But even assuming he has a disability, that disability is not the issue in this case as far as reasonable accommodation, because the Tri-County transfer station tried to find a reasonable accommodation and could not. We believe, and some of you have talked about this contraption apparatus, whatever the appropriate word is for this. Number one, the apparatus has never been approved by any organization as being safe on the road. As the commission knows, there are significant rules involving the driving of trucks and the driving of trucks with appendages. That appendage was never approved by anyone, and Mr. Stanley, who was one of the respondents here, actually has, as he sent to the commission, a license about investigation. He was of the belief and told Mr. Lehman he did not believe that this was a safe contraption for the road or a safe contraption for the dumping facility. And it's not safe because he doesn't know when it's going to break down or fall off or what it was. I, as the commission has, applaud Mr. Lehman's ingenuity. It's actually a marvel of ingenuity that we Mainers would marvel at, because he took a variety of different things he had around and made them into this dumping facility. But it's not a safe contraption for this dumping facility, and it's not safe for the others. And finally, and he was told, it's not safe for the road. So this is not a reasonable accommodation. It was ingenious, thoughtful, but not safe for this dumping facility. We believe that the investigator did an excellent job in doing the investigation, talking to all of the people involved, getting an understanding of what was happening on the ground, and finally deciding that there were no reasonable grounds. In this situation, I get and understand Mr. Lehman's belief in his disability, which is belied by all the other work that he does, and belied by the work he does collecting trash. I understand his emotion, believing that he is being denied something he should have, but the evidence is there is no reasonable grounds in this case, as the investigator found. Thank you, and I'm happy to answer any questions.
Thank you. I see a number of hands from commissioners. We'll start with Commissioner Ashby.
Thank you. If the complainant uses this contraption, it's really not a concern of yours whether the rules of the road prohibit it from being traveled on the road, correct? It's not an issue for you folks at all, accommodation or otherwise.
So it's not a concern of a public facility that someone is breaking the law to drive a truck to that public facility where others may be hurt on the road. I think that's not the kind of short-sightedness that one would think any public facility would take.
Okay, well, our record's quiet about whether or not it's a violation of the law, but I'll move on. So in the event that he does bring this contraption or any other contraption to you folks, and you aren't required to open your gate for him to use it, it's really not a question of accommodation at all, is it? If you say he can't use it, it's really straight up discrimination. If it in fact is something that otherwise could be used.
Well, it is not unlawful discrimination to make a decision as a reasonable decision, as Mr. Stanley did in this situation, that this is not a safe apparatus or contraption for that dumping facility. For the commission to substitute its belief that somehow this Rube Goldberg contraption is, number one, safe when the person who's running the dumping facility doesn't believe it is, and number two, can be used without danger to others, danger to the staff, and danger to Mr. Lehman, seems to me to be a huge leap. And Investigator Hurd both saw the contraption in action on film and listened to the witnesses. So we believe, and we believe it's reasonable, not to substitute the commission's decision that this contraption is both safe for the road, safe for the dumping facility, and safe for everyone else around it, but to rely upon the experts who believe that in fact it isn't any of those things.
Well, our record is a little thin on what sort of analysis of this contraption was undertaken. The investigator indicates that he really didn't feel he could comment on the merits of it. It looks like the investigator relied upon the respondent who, I'm looking at footnote number 5 on page 6, who saw the apparatus firsthand, did not believe the contraption was sturdy and reasonably thought that it posed a hazard to other patrons. First of all, is it in the record as to whether or not an employee of the respondent actually witnessed the device in use?
Yes, it is in the record, and there's a video of it. And in fact, the people at the dumping facility, including Mr. Stanley, they have dozens and dozens of years of experience with people dumping trash there and the safety of people dumping trash there. So to say that there's nothing in the record about the safety of this, it's clearly unsafe. It's a metal and plywood extension that protruded a significant length off the end of the tailgate and would more than likely fail a safety inspection. And in fact, Mr. Stanley, who is a vehicle safety inspector, said that. On top of that, there's no understanding of how long or what will happen with this. It's ingenious. It's an attempt to try to fix a problem, but it is not and cannot be a reasonable accommodation to say some unsafe Rube Goldberg contraption put on the back of a truck is the be all and end all of fixing this problem. It isn't. It actually creates other problems.
Is the basis for the respondent to tell people that their transporting device is unsafe, is the basis for, and therefore can't be used in the facility, is the basis for that authority by rule, or is that purely discretionary on a case-by-case basis?
In this situation, it's discretionary. Certainly, it's unique. Never happened before, but it certainly is discretionary.
So if an individual comes in without an inspection sticker, for example, or bare tires, or an exhaust that doesn't work, is that a basis to tell them that they can't use that vehicle to transport trash to the facility?
Though I love the horrible hypos, none of them apply in the situation.
I'm sorry, I misheard. Did you actually say horrible?
I did.
Okay.
We used to call, in our law school days, that's what we called the horrible hypos.
All right, that's fair.
When the Socratic method kept going further and further into issues that really did not deal with this specific issue. This specific issue is whether this contraption applied. No, I don't think that if he had bald tires, unless he was skidding into the gate, or if he had no appropriate safety stickers or inspection stickers, unless they were affecting the dumping, which is what's happening here. So I apologize for using the word horrible hypo, but I had.
No, I thought that was amusing. I assure you, I don't take it seriously at all.
Thank you. We were going down a slippery slope, but I was sliding myself.
Thank you, sir.
Thank you.
As I understand it, he was doing this for, he said 25 years. I thought the record said 30 years. And the facility said that he couldn't do it anymore because they had been told either by a state inspection or by an insurance company, or both, that you couldn't open the gate for him. Is that correct?
Yes. By both.
Is it an inconvenience to the facility to have someone open the gate?
No, actually, it's not a huge inconvenience to open the gate. It's just a huge safety hazard. And so they were told both by the state, and that's in the record, and by their own insurance carrier that, in fact, they may not be insurable if they kept the gates open because their policy provides the gates must be closed at all time.
So has the insurance company been consulted, or the state conducted an inspection of him dumping using his apparatus?
Not that I know of. No.
And focusing on that same footnote that Commissioner Ashby was, that's what I wanted to look at in that same regard. Respondent who saw the apparatus did not believe that it was sturdy. So
yes, that's correct.
You say that you can't open the gate for him, and you cite state authority and insurance company, and then he comes up with a possible solution, and you say, well, we don't need to consult the insurance company that we cited as the reason for changing our policy, or the state that we cited as our reason for changing our policy. We don't think it's safe.
Well,
is that a fair synopsis of what we have?
Not a fair synopsis. I don't think that the person who was making that decision did it with some sort of malice. He looked at it. It was, and there are videos and photos in the record. It does not appear to be safe. He is a person who's worked at this facility for more than 20 years. He was concerned about Mr. Lehman's safety, about the safety of others, and the safety of using this at the dumping facility. They thought it was safe for 25 years to open the gate and accommodate it that way, right? It was not safe for 25 years. In fact, it was inappropriate to open those gates for 25 years. And now there have been numerous deaths and injuries because the gates were open. And they made the decision in 2020 to close the gates for everybody, all of the commercial haulers. We're not talking about just Mr. Lehman. Any commercial hauler there did not have the gates open anymore. And they had been closed before for all of the residential people, which is what this facility mainly is for. You can't have one person coming in and saying that he has a disability, and then they go through a scenario trying to determine, number one, what the disability is. Number two, believing that he has a disability, they go through a scenario of trying to find a reasonable solution, and there are none beyond him dumping from his truck, which is certainly a reasonable solution to the situation. Sometimes there are not easy answers to hard questions, and this happens to be one of them.
Mr. Douglas,
My questions have been addressed for now. Thank you.
okay. Any other commissioner questions or responding at this time? Seeing none, complainant used all of their time. Mr. Brogan, anything to add before we wrap up?
How much longer do I have now?
Well, that's a good question. I see if I can determine that, because I unfortunately reset my clock. Let's say 30 minutes.
So again, thank you. There's nothing flippant about this. No one wants Mr. Lehman to believe that he's being treated unfairly. This situation involves safety and a responsible reaction to what the safety concerns were. I understand this ingenious apparatus is sort of makes it look like it's an easy solution, but it isn't. There's nothing to show in the record that it's legal. The discretionary evaluation of the people who work there certainly should hold weight with this commission, as should the investigation by its investigator, who listened to the witnesses, listened to each and every one of them, and made the final determination that, in fact, there are no reasonable grounds. We believe there is no discrimination here, and this is a reasonable solution to a difficult problem. Thanks.
Thank you. So commissioners, you've heard from the parties. Now we'll hear from the investigator, Colin Hurd.
Good morning, commissioners. Really, the only thing that I want to add to my report, and it seems that it's already been talked about, but I just wanted to emphasize it, was about the apparatus. So really what it came down to was that, I did see the video of it. In my personal opinion, it looked fine, but the respondents, I believe it was Mr. Stanley, saw it in person and made the determination that it was unsafe. I did not feel that it was my role to make that assessment, to be able to come to a conclusion whether or not something was safe. So I deferred to the respondent who was there in person and saw it in operation. Although I do want to clarify that a question was asked earlier about whether it was in the record that an employee had witnessed its use. And I believe that obviously he saw it in person, but as Mr. Lehman contended earlier today, I don't think that he actually got to demonstrate cranking it for him. I believe he just saw it and said, he can't use it because it's unsafe. That's all I have to say, and I'm ready for any questions you might have.
Thank you. Commissioner Ashby.
Well, I do want to address that very point. It's a little bit unclear as to whether you deferred wholly to the respondent's employee or whether you had some thought about whether that view of this contraption was reasonable. Your footnote 5 does say that the employee reasonably thought that it posed a hazard to other patrons. Do you remember or recall why you used that word at that point?
Based on his description of the apparatus, I believe it says in there that it was, I can't remember the exact word, but that it didn't seem stable or something along those lines. I only saw a video of it from one perspective, shot by the complainant. I mean, again, it honestly, it looked okay to me on the video, but I really don't think that I don't think that I have the credentials, and I don't have any background to make a decision on its safety. So yeah, that was the ultimate decision I came to.
Thank you.
Commissioner Walker.
Thank you. I'm reading your findings of fact and have a question about the modifications that were considered by the respondent. And it lists 4. We talked about it briefly, that you could dump trash on the floor, could close half the building, or permit the complainant to dump his trash after hours. Were those proposed by the complainant, or were those things that were brought up within the respondents trying to find a modification?
It's my understanding that that was the respondent's attempts to come up with a solution, that those were not proposed by the complainant.
Okay, do you know if they were ever discussed with the complainant or just outright determined to be unreasonable?
I believe they had a discussion amongst themselves about this, and then told complainant that they couldn't come up with a solution, a reasonable solution.
I also wonder if the insurance and the state inspections would have had different outcomes if the respondent and other haulers, frankly, had their own time when it wasn't open to the public. So if the gate is there for safety concerns and there was no public there, only the haulers, would that be an issue?
I'm not sure that
I'm asking that. I know other waste disposal places do have special hours for haulers.
I'm going to ask commissioners and the investigator to limit themselves to what is actually in the record for this case.
Thank you.
Oh, are you still looking to me? I don't know that I'm
okay.
Again, I don't know that I'm qualified to answer that question. I mean, that as you phrase it there, that sounds reasonable to me, but I don't know that that was considered by respondents or or offered by complainant in this conversation either.
All right, that's good. Thank you.
Any other commissioner questions for the investigator? Seeing none, thank you, Colin. So
Thank you.
commissioners, we would be looking for a motion for motions. There are two proposed findings. Commissioner David?
I propose to take them separately, and I'm gonna make a motion on the second one first. I propose that we find that there's no reasonable grounds to believe that respondent retaliated against complainant for statutorily protected activity.
Commissioner Bryan, second. So it's been moved and seconded to find no reasonable grounds on retaliation. Is there any discussion among commissioners? None. If you are in agreement with the no reasonable grounds finding on retaliation, you'll vote yes. Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner O'Brien? Yes. Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
Thank you.
And then I would move on the first one, contrary to the recommendation, I would make a motion that there are reasonable grounds to find that respondent discriminated against complainant on the basis of the disability, and conciliation should be attempted.
Is there a second?
Second.
Well, it's been moved and seconded to find reasonable grounds to believe that respondent discriminated on the basis of disability. Is there any discussion? Seeing none. If you're in agreement with the reasonable grounds finding of discrimination on the basis of disability, you'll vote yes. Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner O'Brien? Yes. Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
So it is a finding of reasonable grounds to believe. So there's one reasonable ground and one no reasonable grounds. And the commission will send counsel and parties a letter confirming that, and we thank you for participating here today.
The next case on the agenda is E 21-0404. That is Juan Davis, Scott County Commissioners. That's a no reasonable grounds case. We'll hear from more of his attorneys.
Okay, we're unsure who's here in person. I believe respondents counsel is. I believe Mr. Davis was going to also be here. Thank you, Barbara. It's interesting to watch, isn't it? As we get farther and farther in time, more and more people coming in person.
Yeah.
Soon it's going to be just our staff.
I'm not sure that there's any relationship between that, the actual prevalence of
Oh,
COVID out there. We've
agreed.
been seeing outbreaks
Yes.
lately.
No. I thought about it this morning. I said, well, we could let everybody sit in here all together, because that's what they want to do. They don't like sitting.
Thank you.
People.
I've been telling people, I don't have a number. I was going to say, it's not your case. Wait in the room. Good morning. We're just waiting to see if Mr. Davis is here.
Mr. Davis is here. He's at the washroom. He'll be back momentarily.
Oh, thank you.
Is there a particular place where you'd like to have parties?
Nope. He will be going first, so he'll be at the podium. But anywhere you want to sit, looks like all the tables are kind of scooped up. Sorry about that.
That's okay. Thank you.
And lunch should be coming at 11:30.
So they're open.
They're open.
That's good to know.
2 minutes?
That's good.
Do you want to take 2 minutes?
Yeah.
Sure. Go ahead, yeah. I mean, actually, let me ask the chair.
I'm sorry, yes,
Preliminary.
of course. God, I don't want to be in control of that. Someone needs a break.
Right,
Keep up.
nobody has to.
Yes. I mean, that's taking power to its.
My family has told me to stop executive directors. Okay, go ahead. Thank you, Martin.
Oh, I right. Well, I think he's referring to a commonly used term. and I-
Or parade of horribles?
The horrible.
It's the parade of horribles. We use that in law school.
Yeah.
I used that in a meeting the other day, and the person on the other side of that was not pleased with that phrase either.
I'm glad I learned that. I'll try.
And I had to apologize. But it was just a thing you learn in law school. It's like an example of the escalating
So what's
consequences.
it called?
When I learned it, it was called the parade of horribles.
Okay, I'm gonna use that at home. See if he gets it.
Nobody seems to really like it.
Sports.
Yeah. Hey there, we're just waiting for commissioners to come back. We do require masks. There's some right there.
Okay, thank you.
Yeah.
Interesting how one lemon sticks.
Rube Goldberg.
Goldberg, that's good stuff.
He used the
Only
word.
old people get that reference.
Used that like 6 or 7 times. Very interesting.
Yeah.
Very interesting choice.
Nice. I mean, just see. Yeah, I agree. Look at you actually brought. I'm shocked. Very pleased.
So this whole decision not to have the box of Joe, I think. Really not an appealing decision,
Okay, so we should go back to boxes, Joe.
but I don't know. I mean, I don't want to be a prima donna. What's the difference between the copies you bought and the difference of cost between the copies you bought and the box?
The
you
only
got?
person who asked, only one person asked me to get the copy.
That's me.
Yeah.
That's terrible. Tell you what,
Get
I'm
a large.
not gonna get a box of Joe from me, so.
Well,
It's taxpayer money we're talking about here.
It is fair money.
This is the coffee you got?
Well,
Yeah.
You need a large.
Well, yeah, how about a large next time? That'd be
Okay,
good.
a large.
How about as big a coffee as you can get me?
I misunderstood. You wanted us to tell you if we wanted you
if
to
you,
get us
yes,
coffee.
yes.
Yeah, I
misunderstood.
Oh, you
Man,
want-
I was all over that.
So you guys do want coffee?
Yes, yes.
Okay, maybe I'll go back to the box of Joe because that's just,
Yeah. I think
just we end up every month throwing away a lot, but I think it's cheaper to buy a box of Joe for $20 than it is to get 3 individual large
Or at least comparable, because I'll probably drink 2.
coffees. Okay, well, you made an argument right there.
Thank you.
Okay, box of Joe back on.
Thank you. Very important legal business that we're
It is
discussing
very
here.
important.
I think we're ready. Are we ready?
No,
I thought I- Oh, yeah, we should have all of our commissioners probably.
And by the way, I love the spring thing that you're doing there. First day of spring. I'm with you. I'm with you there. Yeah, a whole debate about that before he got here.
Yeah, some sort of like,
No,
thank you. Roll it, thank you, yeah, roll over. All right, we are here on E 21-0404. That's Mr. Davis versus Penobscot County Commissioners. Mr. Davis is to go first. It's a no reasonable grounds case.
So Mr. Davis, right up here at the podium, if that's okay with you, are you comfortable presenting from there?
Pardon me now?
Are you comfortable presenting from this podium here?
I guess, why not?
That is typically where people go because there's a microphone there. So you have 10 minutes. And I'll just remind you not to use the names of anybody who's not named as a part.
Yeah, I got a problem hearing you.
Okay. I would just remind you not to use the names of any people who aren't named as the respondent. So don't use any individual's names.
Okay.
And you can take your mask off while you're presenting.
Now, I'm a novice here. I don't know.
I'm not allowed to tell you how to use.
Okay. Well, I have a discrimination case. I've worked for the Penobscot County Sheriff's Department for approximately 8 years. Of course, when you get to my age, time flies, so I have a hard time to determine age and age. 7 or 8 years, I guess. And in that time frame, we had a deputy that repeatedly said that some folks are too old to work. And we had a sergeant who at the last meeting said that that deputy said that he hoped that he didn't have to work when he was our age. But that was one time versus 7 or 8 years, probably 100 different occasions. That deputy said that anyone of elderly age, meaning over 65, shouldn't be working. I was 69, I guess, when I started. I'm 77 now. And I enjoyed the highest success rate of any part-time deputy, and most of the time the full-time deputies, in services done, performance-wise. So I guess we just go on to the pandemic. I have a little COPD, and my doctor said that she felt, because I was a little overweight also, I forgot to add that. I tend to forget that she would prefer if I didn't go into settings that had a lot of people around, like apartment houses, courthouses. Of course, we were stopped in the courts system for a while anyway. So she wrote up okay, return to work, is fine. And she put light duty. Well, I went back and told her that in my area, I had very few apartment houses. And I was fine to go to 2 family houses. So she corrected that and put down full-time without any restrictions. Now, that was the first one that came from the sheriff as a delay. And I sent it in to return to work full-time and waited and waited. I waited so long, like 6 months, I guess, before I started making an inquiry. And my sergeant kept telling me that he would take it up with the sheriff on their regular Tuesday meeting. I in turn would call him and say, did it come up? No. And that went on for another 6 months. So we're at a year now that nobody's contacted me whatsoever. And make sure I'm not missing anything. And then I made a call to him and told him, you know, I guess I'll just hold off here. And the interim, I had talked to the prior sheriff, and he indicated, why don't you just take a break, John? And basically that's what he said. So, because he's the one that actually hired me, that I worked for 7 or 8 years prior to the election. So that's what I did. And I have the first time that I heard from my sergeant, I retained it on here. I think it was 5/21. I don't see it right now. think it's 5:21. And my sergeant called me and said, "You ready to come back to work?" I said, "Sure, I've been ready for a year." And he said, "Well, we've got a new telephone number in the department," which nobody ever told me. "And I'd like to have you come back." Okay. And then I think it was another follow-up call we had. Then he indicated that the territory that I would be given, where I had previously, I was part-time, but I was actually working full-time because I enjoy the job. Where else was I going to get a job at my age? And I spent 55 years in the field. So it wasn't really work to me. So I didn't mind working long hours. So I worked 7 days a week. And I worked long hours. Sometimes I didn't work long hours if we didn't have enough services. That's why I was able to accomplish. I would call up the attorney that gave us the paperwork and say, you know, it's served. And usually that was always within 24 hours. I didn't get the extra money for many multi-service attempts because I didn't need it. I used to say I'm going out to make friends instead of spreading hate and contempt. What's, no saying. And I did. I made a lot of friends. I knew a lot of people. My network actually was quite vast, so I didn't have to do a lot of research to locate folks. I guess, I'm sorry. The sergeant told me that my territory was going to be cut to Newburgh, Dixmont, and Plymouth. That's going from probably the most services I had because the sergeant just did foreclosures because those are easy 1, 2, 3. That's it, you're done. And the other deputy, he covered Clifton to Eddington, and his time frame was really stretched. So lots of times I covered his territory for him, and I filled in for him on vacation full time. And there was a lot of little extras. I used to fill in for lunch hours. I never got paid for that. I was asked by my sergeant to cover for lunch hours. The sheriff walked by one day and said, "Yes, sit there. You can't have a sandwich there." My sergeant told me I could. I believe in following channels. So, and then I could feel the sheriff having some resentment towards me for some reason. And I even did a little research into that situation's background. I found some telltale signs that maybe he would draw some resentment towards me.
I have about 30 seconds left.
I beg your pardon, ma'am?
30 seconds left. I apologize. 30 seconds left.
Oh. The territory that I was offered, which I don't think you folks know, was Dixmont, Plymouth, Newburgh. If we had 2 services a month, that would be a lot. So obviously it wasn't the probably 89, no, I don't know, 30, probably 150 services that I normally was doing a week.
Mr. Davis, that's the end of your time.
Yes, ma'am.
So can you go down, please, if you have any questions from Mr. Commissioners, any questions for Mr. Davis?
Thank you. I apologize if it's in the record and I missed it. Are you paid? Are you paid per service?
Yes, ma'am.
Okay, thank you.
Any other commissioner questions for Mr. Davis?
Because like, I haven't follow up on that.
It doesn't work like that. If they have a question, they'll ask you.
Would you like to say anything else about that?
Yeah, so not to mislead you, Department of Human Services, we would get $5 for a service. Not very much. So you had to have volume. So if I had Dixmont for a $5 service or Plymouth, which is quite a distance away. Yeah.
Thank you. Any other commissioner questions, Commissioner Davis?
Mr. Davis, they're saying, are they not, that your termination was because of budget cuts and pandemic and
So I was
lack
never
of
terminated.
lack of having part-time people.
I was never terminated.
Well, all right, that's a poor choice of words.
Oh, I can
Your
answer.
complaint is that you weren't getting work. Is it not the case that they're saying that was because they had to eliminate part-time people and take it in-house?
That was during and after the pandemic. Shortly afterwards.
Right.
Yes,
Are there now part-time?
I beg your pardon?
Are there now part-time processors?
Oh, yeah, yes, sir. They've been for quite a while. I was the only one that wasn't called back.
All right. Thank you.
Well, when I say call back full time, I really mean back. Anyway. Call back to go back to work.
You say you're the only one. How many others were?
I think there's 10 of us in total.
And 9 of them have been called back and you.
Yes, sir.
Any other commissioner questions for Mr. Davis?
Just to clarify, the territory that you referred to during your remarks.
I'm sorry.
You referred to a territory that you were offered during your remarks where you maybe get 2 services a month.
Yes, that was the new service. That was in the towns that they offered me.
And when
Come back.
When was that offer made?
You know, I don't know the date.
Okay. Recently though.
Not that long ago. I waited approximately 2 years for a phone call. Now, yeah, I wait, and for 2 years, nobody ever called me. Matter of fact, they even changed the department telephone number, and I didn't know about it.
When you got the call, this was the territory you were on.
Correct.
Okay, all right, thank you.
Any other commissioner questions for Mr. Davis? Seeing none, thank you, Mr. Davis.
Thank you.
Mr. Hamer, did I pronounce that right?
Yes.
Okay.
Good morning. My name is John Hamer. I'm an attorney from Rutland Winchell, here today representing Penobscot County. We deny that there was any discrimination or retaliation that occurred, and we do support the recommended decision. Mr. Davis, as you mentioned, was a part-time civil process server. We initially covered the towns of Hamden, Newburgh, the west side of Bangor, and civil orders of arrest, which weren't geographically tied. It was just wherever they had to go. He worked in a department where there were 8 part-timers and 2 full-time employees. When COVID hit in March of 2020, basically the need for any sort of service stopped pretty much immediately, and it didn't even, there was absolutely nothing to do until May of 2020. At that point, a trickle of services became available, and the county channeled all of its work to its 2 full-time employees. I mean, it was a big hit to the county's budget. And so I believe there were 2 part-timers that were retained, one in the northern Penobscot area and one in the far west, because it wasn't economically feasible for the full-time employees to hit those areas. So I was back in March of March through May of 2020. Mr. Davis was, as mentioned, he was out of work for medical reasons until he was released in March of 2021. At that point, there was still very limited work available. The county was at this point working with $100,000 over budget in that department. So they made a decision that they were going to continue to channel work to their 2 full-time employees as long as possible and as much as possible. Eventually, people were called back and Mr. Davis was offered some work in March of 2022, which he declined as he indicated there. But there was nothing to do with his age or any disability or any retaliation. This is purely an economic decision by the county in response to the lack of services that there were. So the county has been channeling its work to 2 full-time employees and brought back the part-timers as they possibly could. And in a nutshell, that's really all that happened. It's unfortunate. Mr. Davis was a good process server and it was tried to get him to come back a year ago and he declined. So we're here now today. Happy to answer any questions.
Thank you. Any commissioner questions for Attorney Hamer?
Yes, I think I understand the offer of the return to come back to work a year ago related to the service of civil orders of arrest. First of all, is that true? I think that's what the investigator found.
I believe that's what I was told.
And then there's another comment in the investigator's report that says during the IRC, your representative stated that the complainant is cleared to return work and may accept assignments from the respondent if he chooses. Is that still that same civil order of arrest work, or do you understand that offer to be a broader offer of work at this point?
I don't know what kind of work is available and what territories are available at this point. It's been a year since he was offered some return to work and which he refused. So in the meantime, I don't know how the work has been handled. If he wants to return to work, then the department would have to see what's available and make post work as it becomes available. I don't know if it's been filled.
Thank you.
Any other commissioner questions for Attorney Hamer? Thank you.
Thank you.
So this time, complainant has used all of his time and respondent has presented. So this time we would hear from the investigator. This is a case that Courtney Byrne investigated and Jane O'Reilly is presenting her report.
Good morning, commissioners. As Amy just mentioned, Courtney Byrne was the investigator on this case. I have read the file and reviewed the report. I just want to point out a couple things just because they were asked. As Attorney Hamer mentioned, there's nothing in the record about any kind of offer made once the close of evidence was sent, once the investigation was concluded. So all we have are what information was presented as part of the investigation. And it was that these basically the service area where complainant did a lot of his work pre-pandemic is still at the time that this record closed was still being serviced mainly by a full-time employee. There was no work being offered in the area that complainant usually did his work, and he was not willing to do the work that was being offered because it wasn't cost effective for him. I don't have anything else to add, but I'm happy to answer questions.
Any commissioner questions for the investigator? Commissioner David?
Yeah, you just said that he was not willing to do the work that was offered. What was that?
Yes. So both in the IRC, I believe it's mentioned in footnote 8, right after in the facts section, sentence L. So in March, but also again, I think in September of 2022, complainant was offered some work. He was called up and said, there's work available in this area doing civil arrests, civil orders of arrests. But complainant explained at that time in the conference that the cost effectiveness of doing that work for him was not feasible. Like the amount of time he'd have to spend driving there versus how much money he'd make doing the orders of arrest. He told the investigator in the conference that he responded to the sergeant, I don't want that work. I can't do that work. That's not feasible for me.
Sorry, I missed it.
Any other commissioner questions for the investigator? Seeing none. Thank you, Jane.
Thank you.
So commissioners, you've heard from the parties and about the investigation. At this time, we will be looking for a motion or motions. There are two proposed findings.
I'll move to take them together and move that we find that there's no reasonable grounds to believe that it's unlawful discrimination on the basis of age and disability, and no reasonable grounds to find retaliation, and blame should be dismissed.
There a second?
Second.
So it's been moved and seconded to find no reasonable grounds on both claims. Is there any discussion among commissioners? Seeing none. So if you agree with no reasonable grounds findings on both claims, we'll vote yes. Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner O'Brien? Yes. Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
So both claims, there are no reasonable grounds findings. And the commission will send both parties and counsel a letter confirming that, and we thank you for your participation today.
All right, the next case is MHRC case number E 22-0044. That is Melinda Karen versus the Lewiston.
That is the one that was tabled.
Oh, I'm so sorry. Postponed. Thank you so much.
I know it's hard to keep.
My note even say that.
We changed it the last minute. That's hard to keep track of.
Forgive me. But I'm stumbling to the end of the agenda. All right, let's try again. The last case we're going to deal with the agenda is MHRC number H22-0297. That's profiled with HUD number 0123-268. That is Raymond Farrell Jr. versus Lisa Warren. That is a no reasonable grounds case. And we should hear from Mr. Farrell or his counsel.
I believe Barbara was checking to see if he was here.
$5. Yeah. You know, the first thing I thought we said that is that's gotta be a wage an hour. Do those.
Yeah, that's just
after.
Appreciate it.
Yeah, the makeup a job is worse in class action.
Guess I'm going here.
Well, actually, if you can hold on just a second.
Okay.
Thank you, though. You're Ms. Warren. So yes. Okay, well, first, we would be checking to see if Mr. Perrell is here. And I don't see him online. And I will say he did ask for extensions repeatedly. We did grant them several times and then we denied them. So. Yeah. I don't see him present. Typically, when the person challenging the investigator's recommended findings, if they don't appear, the general practice usually is that the commissioners vote to adopt the recommended findings.
Move that we vote to adopt the recommended guidance.
And in this case, the recommended findings are no reasonable grounds. Second. I thought this one.
We don't see those histories of
No, you don't. I do not. That's procedural.
Yeah.
Yes.
Okay.
But it's
If there's a substantive issue, you guys would probably hear about it, but if it's a routine procedural matter, we don't generally.
I hear what you're doing. In the probative sense,
it can be
over and over again.
Can be, yes.
More prejudicial than probative.
Thank you, counsel. I think it's been moved and seconded. Are we gonna have any discussion?
Any relevant
Yeah,
discussion?
relevant.
I'm here. Thank you
Yes,
for
you
being
are.
I should correctly here. So moved and seconded and discussion related to the motion. Seeing none. So the motion is to find no reasonable grounds of discrimination. Nope, and retaliation. So if you're in agreement, you'll vote yes. Commissioner Ashby.
Yes.
Commissioner Davis.
Yes.
Commissioner O'Brien. Yes. Commissioner Douglas.
Yes.
Commissioner Walker.
Yes.
So the findings are no reasonable grounds. And so you didn't even have to go up and talk. I just want to spare you that. Thank you for being here.
Wasn't my favorite hobby either. Please show a nice day to drive. I did, but it was a long drive.
We appreciate you being here.
Thank you.
We'll send the letter confirming the no reasonable grounds find.
Beautiful. I appreciate
Thank you very
that.
much.
Thank you.
Thank you.
Have a good day.
Thank you,
Spring.
Thank you.
Are we plowing into executive session or are we having lunch?
Lunch will be here in 25 minutes. 5-minute break? 5-minute break?
5-minute break?
Sure. Yeah, good idea.
We could figure out the technology between now and then, right?
Well, yes, so we shouldn't need to move anybody electronically
Oh, that's true.
into the
Just
second,
turn it off.
we'll just turn that off.
Great.
Pause it. And we should be fine. If we turn the mic off, we should be fine.
Great, 5-minute break.
How many trying to? And actually, thank you. Can you hit the button on top of the microphone there? Not that one. Oh, you're turning that one off.
No, which,
The microphone we use is the one that's on the podium. It's a little round dot
This one?
at the top of it.
oh,
Podium.
I think it was on already. I think.
Yes.
Unmuting that, just unmute this.
So can you be?
This is the YouTube.
It's a little round.
I had YouTube up, just so we could hear.
Okay. So, we're back in executive session. We would be looking for a motion on cases not to litigate.
Oh, okay, I'll try. I'll move that we accept our council's recommendation to not litigate a series of cases we had discussed in her litigation report. That's one.
Okay, it's been moved and seconded that the commission should not initiate litigation in the following reasonable grounds cases in which conciliation was unsuccessful. E200460, E200466, PA 200491, PA 200518, and H220222. So it's moved and seconded. Is there any discussion? Seeing none, if you're in agreement with not litigating those cases, you'll vote yes. Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner Bryant? Yes. Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
Okay,
And I move that we approve settlement of two cases that were subject to litigation as represented to us by our counsel in the executive session.
is there a second?
Second.
So the motion is to approve settlement of Fagan versus St. Joseph's and Janelle versus respondents that I cannot remember right now. Simmons et al. Simmons et al. And if you are in agreement, you will vote. Wait. Motion second, is there any discussion? Seeing none. If you're in agreement with settling those two litigation matters, you'll vote yes. Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner O'Brien? Yes. Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
That's it. So now it's noon and we are waiting for our friends from OIT to get here with iPads.
Well, that's right.
I forgot about that until just a minute. I did email them. You guys are all packed up like you're leaving.
I was just on my way to hit the road.
Ha, ha.